Good evening, everybody. Thank you for making it here this evening. I am Kshitij Kasi Vishwanath, and I am your moderator here today. And moderator here today on today's session, the constitutional amendments that have defined an endangered and preserved liberty. This is part of a very long series of events in our college, which come under the bracket of Azadi Ki Amrut Mahotsav. So with that being said, I hope everybody over here has a very enjoyable session today. And I would like to give it to our faculty convener, Ms. Afreen Khan, to introduce Mr. Nipun Saxena.
Thank you, Kshitij. I hope I'm audible to all of you. All right, good evening once again, everyone. And it is a privilege and an honor for me to introduce our guest speaker for today. Our guest speaker, Mr. Nipun Saxena, as you all must be aware, is a practicing advocate of the Supreme Court of India. Along with that, he practices in the Delhi High Court and in various other high courts, judicial and quasi-judicial bodies. He has a very diverse and a rich profile, and it wouldn't do justice if I were to just read it out. But nonetheless, as a part of protocol and as well as the kind of experience he has and the expertise he possesses, it is my duty to read out to all of you as to what all Sir has achieved. The Sir is also a visiting faculty at National Law University, Delhi. Some of the landmark judgments that you can look at if you were to read about Sir's achievements would be that of setting up the victim compensation scheme for rape victims, acid attack victims. You have section 357 of CRPC. Sir has played an instrumental role in getting justice for the vulnerable sections of the society. One of the judgments that I have been using a lot in my classes during juvenile justice and is a celebrated judgment where Sir has pushed for protection of identity of POCSO victims as well as victims of rape within the Indian criminal justice system. It is based on this particular PIL that the court passed robust guidelines protecting the identity of victims, which was otherwise made a mockery of by the media or various stakeholders of the society. I would further like to also add that our speaker has participated or has undertaken diverse other matters, such as on the civil side, company matters, security transactions, joint Hindu family matters. And on the criminal side, you have Prevention of Money Laundering Act, CBI matters, NDPS. I mean, it is a CV that anybody would want to hear so much and learn so much from Sir. With taking very limited time and I would like to pass on the mic to our guest speaker for today, because we're all here for him, to learn from him, to know from him as much as we can learn within this hour that is scheduled for us. So if the moderator for the session has no other instructions, or if you do, you can explain it to the participants. Otherwise, I would hand over the mic to our speaker now.
Thank you, Ms. Khan, for giving an introduction, which I don't know whether I'd be able to do justice to, but I will nonetheless make an endeavor to take up the matter which now happens to be very close to my heart. I am going to attempt, rather ambitiously, to trace the origins of 4 constitutional amendments which I think have defined, preserved, and even endangered the conception of liberty. And I think it's a fitting tribute to the general theme of the ongoing week, which has been hosted by the institution. Yeah. So I think the first constitutional amendment that I will be talking of is the attempt at defining it. And this is in the context of the 9th constitutional amendment. Now, the 9th constitutional amendment came into being in the year 1960. And what did it provide? There was a pre-existing agreement which was entered into between India and Pakistan, where a part of the territory, which was called the Berubari Union, was sought to be seceded or given away as part of the agreement. Now, of course, the agreement never said that the part of the territory was supposed to be given away, because the agreement drew its strength from the Radcliffe Award, which initially demarcated the boundaries of the 2 nation states, that is India and Pakistan. Except what did happen was that in so doing, the most contentious issue was the fate of West Bengal. And in so doing, the Radcliffe Award clearly said that part of the territory will be recognized as West Bengal and the other part would be recognized as East Bengal, which is now, of course, a precursor to the modern day Bangladesh, right? Interestingly, what happens is that there is also an agreement where this very small territory, which is not more than 8.75 square miles, with a population of only 10,000 people, were excluded from that Radcliffe Award. In fact, a map was drawn, but the map never mentioned this particular area. And therefore, the question arose as to what is the fate of this area? Where does it go? Whether it remains with India, it goes to East Pakistan, where does it hang? And with it hung the fate of those 10,000 individuals who were rendered, if this award were to be given effect to, who would be rendered stateless. And this is precisely where the first question and one of the first references was made to the Supreme Court of India under Article 143. In fact, the central government proceeded to give effect to this boundary dispute and say, all right, we are going to carve out where exactly this particular state goes and what happens to the people who are living there, whether they are citizens of India or they are citizens of Pakistan. In fact, the state of West Bengal objected in saying that, look here, Berubari features part of West Bengal, which now also finds its mention in the first schedule to the constitution under Part A, which is all the territories which shall form part of the Union of India. And therefore, on conjoint reading of Article 1, Subclause 3 and Article 3, the only irresistible conclusion is that Berubari shall follow for all instance be part of the Union of India. There was another very interesting argument which was raised by Mr. Chatterjee, who was arguing before the Supreme Court, appearing for various parties who were in favor of retaining Berubari as part of the Union. Interestingly, the Attorney General argued against the proposition and said that the part of Berubari in terms of the International Tribunal's award must go to Pakistan. Now what happens is that the Supreme Court of India constituted a 7-judge bench, and the judgment, of course, was delivered by Justice Gajendra Gatti. Now what happens is that there were fundamental questions, and I'm not going into the detail of that judgment because it's a fairly lengthy judgment, but I will only look at 2 specific issues, which is definition of what you would call a citizen and defining how sovereignty is attached to that conception. Because the argument which was made by Mr. Chatterjee before the Supreme Court was that if India were to secede part of its territory to a foreign nation, whether in terms of an international agreement or in terms of an award of an arbitral tribunal, the difficulty would be that India is also giving up its sovereignty and consequently the liberty of all the individuals who claim to be citizens of India. The argument from the opposite side was that the word sovereignty means the power to acquire as well as the power to give up. And whether the nation state has power to give up as well as the power to acquire must for all times to come remain with the nation state. And therefore, there are no fetters that can be imposed on the government or on the nation state in deciding whether it must go this way or that. The Supreme Court of India, of course, while taking a larger view, saying that the power of sovereignty, which is the defining concept, will stay with India in the sense that it has the power to decide whether it wants to secede part of its territory or not to secede part of its territory. It can also acquire as many territories as it wants to, but being cognizant of the fact that there are 10,000 individuals, they have not, under a social contractarian arrangement between the nation and the state, given away their liberty. In fact, the state is the custodian of the liberty of the people, and therefore the state cannot do it. it can do it only and only if it decides to amend the constitution. And of course, an amendment must be introduced to both Article 1, Article 3, as well as to Article 368, thereby making it extremely, extremely difficult for the government of India to in fact secede those territories. Right. Now, one problem with the judgment, as I saw, was that the judgment says that the word sovereignty featuring in the preamble will not come to the aid either of Mr. Chatterjee, which is of course on behalf of the government of West Bengal, or other citizens who had filed numerous 32 petitions before the Supreme Court, nor will it come to the aid of the government of India, because the words featuring in preamble cannot be used to interpret the constitution. That was 1960 view of the Supreme Court, right? Of course, in the later parts, when Keshwananda Bharati, Minerva Mills, and I.R. Coelho, all those range of judgments decided to take a completely different view of the matter. And naturally, since Keshwananda Bharati was rendered by a bench of a superior bench strength, which is 13 judges, the question was no longer assented. Right? So this was, so far as the first conception is concerned, right, which is defining. The second one, which is endangerment, is something which brings us to not one constitutional amendment, but to my mind, it would attract at least 3 constitutional amendments. And I will tell you exactly why those 3 constitutional amendments offered a death knell to the heart of privacy, to the heart of individual liberty, and to the heart of rule of law itself. The first of such constitutional amendment was the 24th Amendment Act of 1971. Now, this 24th Amendment Act of 1971 was introduced on 5th November 1971. I mean, it was passed on the 5th of November. It amended Article 13 and Article 368 of the Constitution. And in fact, it tried to upset the judicial findings rendered by the Supreme Court in the case of IC Golaknath. Because in Golaknath's case, the Supreme Court of India had unequivocally stated that the Parliament had no power to amend the fundamental rights. So the then government, ruled by Mrs. Gandhi, decided to bring about this amendment, completely unsettling the law as was laid down by the Supreme Court in the Golaknath case, and said that the Parliament has every right to amend even Part 3 of the Constitution. Right? Now, on a simplistic view, it looks like a very innocuous amendment. But now it's not just one amendment that I will be referring to. I will also mention other amendments, and then we will look at the conjoint effect of all the amendments altogether, especially in the context of the prevailing circumstances of that time. The second amendment, which was of course introduced, was the 38th Amendment Act of 1975. Now, this 38th Amendment Act of 1975 made a couple of things. First, it made declaration of emergency by the president non-justiciable, which is to say, Article 37 treatment being afforded, which means that if something is non-justiciable, it means that you cannot approach a court of law. Second thing that they did was they made promulgation of ordinances non-justiciable. So while under Article 352, as you are aware, as soon as emergency is imposed, the Parliament goes into suspended animation, which is to say that the Parliament today cannot hold any session if there's an emergency in force. So then how do law, how is the law governed in that sense? The law is laid down by way of promulgation of ordinances under Article 123 and 213. And the same can only be done by the president on the aid and advice of the Council of Ministers. And if these promulgation of ordinances cannot be called into question before any court, then it becomes and it makes that ordinance immune from judicial review. So what this sinister amendment does is that it introduces the non-justiciability component and extends that logic not only to the imposition of emergency, but also to promulgation of ordinances. Now, the third thing that this amendment seeks to do is that it gives power for the very first time to the president to promulgate multiple emergencies simultaneously during a period of time under different grounds. Now, under Article 352, as it existed back then, there was internal disturbance on the basis of which emergency could have been imposed. We all know that the word internal disturbance was done away with under the 44th Amendment Act. You know, those basics of constitutional law, I hope and pray everybody is well aware of, right? But let's come back to Article 352 and let's come back to the way 38th Amendment Act modifies it, because now it says that the president today can impose national emergency in any part or the whole of the union on multiple grounds simultaneously. We only know of one emergency, which was promulgated on the 26th of June 1975. But imagine a situation where, in addition to 26th June 1975, on the next year, with let's say 25th of June 1976, the president promulgates another emergency under a different law. This would mean that there would be a recurring phenomena of emergency after emergency with no recourse to judicial authorities or constitutional courts. And it was in that light that you would now see how sinister this amendment was. Let's now look at another amendment, which is the 39th Amendment Act of 1975. Let me set the context to 39th Amendment 1975. What happened was that there was that famous case which was decided by Justice Sinha, the election dispute between two contestants, Mr. Raj Narayan and Mrs. Gandhi. Mr. Raj Narayan had accused Mrs. Gandhi of engaging in corrupt and illegal means and made as many as 30 to 40 grounds on the basis of which the entire election was held, at least, I mean, was alleged to have been tainted. And therefore, Justice Sinha had, on June 12, 1975, passed a decision to the effect, because, of course, just to give another context, that at that point of time, there were no specific election tribunals. The matters concerning elections of prime ministerial candidates used to be filed before the High Court itself, right? So the Honorable Allahabad High Court on June 12, 1975, passed a decision saying that the election of Mrs. Gandhi is declared to be invalidated on account of corrupt and illegal means. Number two, that we also understand that Mrs. Gandhi is a sitting prime minister of the country, and therefore, though she no longer is a member, she will continue to remain in office for a period not exceeding 6 months. And third, that even while she is in office, she will not be allowed to cast a vote. Naturally, there was an appeal. June is a time when, as lawyers, we regale in times, because it's Supreme Court's vacations which are going. Right? So before a vacation bench presided by Justice Krishna Iyer, an appeal, a special leave petition was filed, seeking a prayer to suspend and stay the effect and operation of the judgment impugned therein. And Justice Iyer did not do so. And therefore, the judgment passed by Justice Krishna Iyer was on the 24th of June, and the emergency was imposed on the intervening midnight of 25th and 26th June, which is to say immediately day after, by the then President, Justice Fakhruddin. Now, what happens is, interestingly, that all of this is happening in June. Under the 39th Amendment Act, which is now incorporated, or which is now inducted formally on the 1st of August 1975, the first thing which is done, in fact, 10th of August 1975, 1st of August was the 38th Amendment. On the 10th of August, a very troubling amendment was introduced, which is to say that the disputes relating to president, vice president, speaker, and prime minister shall not be called into question before any court. This amendment, students of constitutional law would say that, of course, this will only operate prospectively. This amendment had the dubious distinction of being the amendment which also applied retrospectively to every pending proceedings before any court. In fact, it in so many words introduced this particular Article 329A, subclause 4, subclause 5, and subclause 6, which in 3 different instances conveyed one meaning, and that meaning was to defeat the effect of the judgment passed by the Allahabad High Court and the refusal of the stay order by the Supreme Court, which effectively said that even if there is any proceeding pending before any court or any tribunal, and notwithstanding any judgment being rendered in respect of those disputes, the matter shall only be decided by such authority as may be constituted by the parliament, by the president, and not the courts. The courts shall not exercise any jurisdiction. And even if the courts have exercised jurisdiction, they will not proceed with the case. Now let's look at the social context in which it was. As a precursor to the 24th Amendment Act of 1971, the one which I referred to initially, right, which effectively did away with the Golaknath decision. Now the parliament can amend any fundamental rights. What was immediately enacted was this legislation called Maintenance of Internal Security Act, or MISA, on 2nd of July 1971. And we all know what happened under MISA. Preventive detentions were being ordered without absolutely any embargo. In fact, the maximum period of 1 year of detention further carried out a proviso to the effect which stated that nothing contained herein, which is nothing contained the maximum time limit for which you can put a person under detention, the detaining authority may order that this order of detention may be modified or revoked accordingly. So nothing is to say that on the 11th month of the 29th day, the detaining authority may say, we want to further extend it by 1 day. And that is precisely what was happening. Now, Article 329A does something also very, very sinister, because it now says that any fundamental rights during the imposition of emergency shall remain suspended. Now, the word shall remain suspended occurred for consideration before the Supreme Court, a 5-judge bench which was supposed to decide the ADM Jabalpur matter. The Attorney General later on remarked, because this was one of those defining judgments where the conduct of every stakeholder, be it a lawyer or a judge, was called into question, because the outcome of the judgment was appalling. It took a regressive view of the constitution and placed us back into medieval era as a society. It shook the conscience. It should have shaken the conscience of the court as well as us, but it failed to do so. I don't know why. But the net effect of it, and as Attorney General himself said, that I pitched it, and these are the words of the Attorney General when he argued the matter before the court. He said, upon a query being raised, that Mr. Attorney General, are you saying that even right to life and liberty under Article 21 could be suspended under emergency? The Attorney General said, my lords, yes, it can. Imagine if Article 21 is taken away from the Constitution merely because there is an impost of emergency. You would have people shooting anybody on streets. There would be absolutely no guarantee. Forget about being produced before a magistrate within 24 hours of your arrest. Now, it was in this context that the question came before the Supreme Court as to whether the enforcement of fundamental rights could be done away or their effect could be suspended while emergency is in place. And the Supreme Court, through 4:1 majority, held that yes, the fundamental rights can remain suspended.